stated in Section 2 of our Constitution. Therefore, Parliament cannot, by simple majority, legislate in a manner which is inconsistent with the Constitution. Notwithstanding the recognition and declaration of our fundamental rights and freedoms in Sections 4 and 5 of the Constitution, provision is made for Parliament to abrogate these rights. Any piece of legislation which is inconsistent with Sections 4 and 5 is required, pursuant to Section 13, subsection 2 of the Constitution, to be passed by a special majority vote of not less than 3/5 of the members of each House. Mr. Speaker, Section 13, subsection 1 of the Constitution provides that, and I quote, "An act to which this section applies may expressly declare that it shall have effect, even though inconsistent with Sections 4 and 5, and if any act does so declare, it shall have effect accordingly, unless the act is shown not to be reasonably justifiable in a society that has a proper respect for the rights and freedoms of the individual." Unquote. The government is confident that this bill is in fact reasonably justifiable in accordance with Section 13, subsection 1. The bill seeks to modernize the criminal justice system and implement critical legislation which will be an invaluable crime-fighting tool aimed at securing convictions and exonerating the innocent. It is the duty of the government to put in place whatever measures may be necessary to ensure the safety and well-being of our citizens. This bill is a manifestation of that resolve. Mr. Speaker, it may be argued that the mandatory taking of a DNA sample affects an individual's intrinsic human right to bodily integrity, infringes personal privacy, and is contrary to the privilege against self-incrimination. Honourable members would know that our Constitution does not afford express protection of the right to privacy. However, Section 4C does recognize the right of the individual to respect for his private and family life. Mr. Speaker, the right to privacy is an issue which is generally cited in relation to the taking, use, and retention of DNA samples. The unique nature of the genetic material found in an individual's DNA can reveal familial relationships, identify physical characteristics and traits, identify genetic disorders, the individual's susceptibility to diseases, and even their ethnic origin. A DNA sample, therefore, contains a wide range of personal and family information. Thus, the retention of DNA samples, even for a specified time frame, as provided in this bill, impacts on personal privacy. On the other hand, a DNA profile which is obtained through the forensic DNA analysis of a DNA sample is a set of identifying characteristics in the form of a code which may only be read with the aid of technology. It is these DNA profiles which will be stored in the forensic DNA data bank indefinitely. It is submitted, therefore, Mr. Speaker, and honourable members present, that the indefinite storage and use of a DNA profile as opposed to a DNA sample mitigates privacy concerns. It is acknowledged, however, that the storage of both DNA samples and DNA profiles can impact the right to informational privacy, which is the right of each individual to retain some measure of control or oversight of material and data which relates to them. With respect to the privilege against self-incrimination, Section 5, subsection 2D provides that Parliament may not authorize a court, tribunal, commission, board, or other authority to compel a person to give evidence unless he is afforded protection against self-incrimination, and where necessary to ensure such protection the right to legal representation. For the most part, provision is made in this bill for the collection of non-intimate and intimate samples without the consent of the person from whom the sample is being taken. This is the case even in relation to the taking of an intimate sample from the alleged victim of a sexual offense. Mr. Speaker, privacy considerations aside, many among us may wish to vociferously object to these provisions on the basis that they infringe the privilege against self-incrimination. That is, the long-established principle that a person should not be compelled to answer any questions or give any evidence that would likely incriminate him in a subsequent criminal case. Mr. Speaker, whilst the government recognizes that the tenets of the Constitution must be treated with the utmost respect, individual rights must be balanced against the overriding public interests. An established principle of constitutional jurisprudence is that no right is absolute, and there are instances in which rights claims should yield to competing social considerations. This is law, Mr. Speaker. In other words, the rights of each individual must be balanced against the right of the state to protect all individuals collectively. And I want to repeat that, Mr. Speaker. The rights of each individual must be balanced against the right of the state to protect all individuals collectively. Because the fundamental human rights of the citizenry are involved, the state cannot and should not act capriciously in these matters, but must show just cause. That is, some compelling moral justification for intervening or imposing limitations on the manner in which an individual exercises his fundamental rights. It is submitted, Mr. Speaker, that in determining the rules to govern any society, priority must be given, inter alia, to the maintenance of public order, the security of the state, the well-being of the citizenry, and the prevention, detection, and prosecution of all criminal offenses. The local case of Morgan against the Attorney General, reported at 1987-36 West Indian Reports, a decision of the Privy Council, aptly illustrates this balancing process. In this case, legislation enacted to restrict increases in rent was challenged. The legislation in question, which is the Rent Restriction Dwelling Houses Act 1981, was passed with a special majority. The appellant landlord sought to challenge the legislation on the basis that it interfered with his constitutionally entrenched right to enjoyment of property and the right not to be deprived of it except by due process of law, pursuant, of course, to Section 4A of the Constitution. In determining the constitutionality of the legislation, the Privy Council balanced the prejudice that might result to thousands of tenants if the legislation was struck down against the benefit of a rental increase to the landlord. The Privy Council dismissed the appeal. The principles outlined in the Morgan case remain relevant even today and support our decision to implement this measure as proposed in the bill now before this Honourable House. The criminal element has virtually decimated the functioning of the criminal justice system and has put our beloved nation under siege. As a people, we say today that we have had enough. I repeat, we have had enough. We recognize that we are no longer fighting for our individual interests, but for our collective well-being and for the future of our children. As such, Mr. Speaker, the government is duty-bound to respond to the needs, hopes, and expectations of our people. And so, it is with the collective interests of our citizens in mind, I appeal to the honourable members on the other side to support this piece of far-reaching legislation. It is time to make meaningful and decisive action. It is time to take meaningful and decisive action, not to oppose because you are the opposition, but I repeat, it is time to take meaningful and decisive action, and in the circumstances, the rights of many must outweigh individual rights. Mr. Speaker, I now turn to the provisions of the bill. The bill is divided into 6 parts and comprises 38 clauses. It would be inconsistent with sections 4 and 5 of the Constitution and is therefore required to be passed by a special majority of 3/5 of the members of each House of Parliament. I elaborated on the need for the bill to be passed by a special majority earlier in my presentation. Mr. Speaker, again, I ask, and I would want to think that the opposition, the parliamentary opposition, would want, if they care about the people of this country, to support this measure. If they do not, they will very soon become irrelevant to the people of this country. More irrelevant. Part 1 of the bill comprises clauses 1 through 4 and deals with preliminary matters. Clause 1 would provide the short title of this act. Clause 2 provides for the constitutionality of this act. Clause 3 would provide for the application of the act, namely, that this act will apply to the investigation and prosecution of offences committed before, on, or after the coming into force of this act. Clause 4 would provide the interpretation provisions. Part 2 of the bill comprises clauses 5 to 6 and deals with the establishment of the forensic DNA laboratories. Mr. Speaker, the Act currently provides that the Trinidad and Tobago Forensic Science Centre is deemed to be an approved forensic DNA laboratory for a period of 3 years after the then coming into force of the 2007 Act, and thereafter the Minister being empowered to extend for a period not exceeding 1 year the length of time that the Forensic Science Centre would be deemed to be an approved DNA laboratory. The government is of the view that these provisions are unnecessarily cumbersome, and we have therefore sought to simplify the process. Clause 5 would therefore provide that the Trinidad and Tobago Forensic Science Centre shall be the official forensic DNA laboratory for Trinidad and Tobago. Clause 6 would provide that the Trinidad and Tobago Forensic Science Centre may, for the purpose of obtaining forensic DNA services, enter into an arrangement with an accredited laboratory. This is a safeguard which will ensure that there is no lapse in the delivery of forensic DNA services in this jurisdiction in the event that the Forensic Science Centre is unable, for whatever reason, to conduct forensic DNA analysis of samples which have been submitted in the course of a criminal investigation. Part 3 of the bill comprises clauses 7 through 11 and deals with the establishment and functioning of the National Forensic Data Bank of Trinidad and Tobago. Clause 7 would make provisions for the establishment of the National Forensic DNA Data Bank of Trinidad and Tobago. This data bank would comprise a comprehensive collection of DNA profiles attributed to individuals or crime scenes, which may be stored indefinitely. Mr. Speaker, it is important to note that the storage of a profile in the data bank does not indicate the innocence or guilt of the individual to whom it relates. Rather, This information provides the opportunity to detect offenders and eliminate the innocent from inquiries quickly. I repeat this for those who are hard of understanding.